Is Bryan Bancroft, 2024 CF 3631. Ms. Osterman Bridges on behalf of the defense and Ms. Gecko on behalf of the state.
Good morning, sir.
Good morning, Your Honor.
All right, where are we at on Mr. Bancroft?
Alexandra Osterman Burgess from Mr. Bancroft, who's present at the podium. Your Honor, we have made a request to the State Attorney's Office for an amended offer. I did not receive a response as to that offer, but did see the state has filed a couple of motions for hearing this morning. I don't know if the state has an answer to that counteroffer. It's willing to put on the record, or we would speak elsewhere.
Your Honor, at this point in time, the state is not willing to negotiate with the defense. They filed or are planning to file a motion to stand your ground. The state believes we either need to have that hearing or set it for trial. At this point in time, I don't believe that we're going to come to a meeting of the minds. As for the underlying charges, the defendant was also charged in the information with the alternative of felony battery repeat offender, which is why the state filed a motion to compel his fingerprints in order to potentially prove that charge if he's found guilty of the lesser included of battery at trial. And so the state would ask for this to the court to grant that motion.
Okay, so the fingerprints motion, yes. What is the state's offer at this point?
One moment, Your Honor. I believe there at one point in time, the negotiations with the defense was either a straight jail sentence or, in the alternative, probation. So the original offer was to stand silent to adjudication, 36 months probation, credit time served for the amount he's been in jail already, submit to a dual diagnosis for substance abuse as well as mental health, and follow all recommended treatment. Do not return to HCA, no alcohol or illegal drugs, and random screens. At one point, the defense asked for a straight jail time offer, and the state extended 364 days jail.
He's been in 272 days.
I believe so, Your Honor.
That's correct, Your Honor. May I have a moment to discuss with my client?
Yes. What does he score if convicted as charged on the score sheet?
It's 33.6 points.
Okay. Okay.
Your Honor, my understanding from Mr. Bancroft is he does wish to move forward with his case to a stand your ground hearing. I'll get that motion filed.
So let me ask the state, is there restitution?
There's no restitution, Your Honor.
There's no restitution. What's the victim's position on the case?
One moment. Your Honor, the victim stated that he believed that substance abuse was an issue for this defendant, and then other than him trying to get help, he didn't really have a care one way or the other.
And when you get done, sir, you going back to Georgia or are you staying here?
I'm not from Georgia. I'm not sure why.
Why they have Georgia down? Where do you normally live?
I normally live in Fort Myers or up here. That's
Fort Myers or up here?
Yes, sir.
So what do you do down in Fort Myers?
Where?
You have family down there? Or it's
No,
just-
my family moved to Georgia a couple years ago. That's why
Okay.
that one showed up.
Okay. Now, why are you in Gainesville then?
This is where I had my surgery done, so I was seeking better medical treatment up here.
Okay. All right. So the state offers you 364. You have a bunch of misdemeanors. You've never had a felony before, and you've been in 272. If you don't score, that I have to send you to prison. You sure you don't want to plea open to me today?
Yes, sir.
Yes, sir, you don't want to plea open to me today?
Yes, sir, I do not want to plead guilty.
Even if you may be going home today and be done with this?
Yes, sir.
Okay,
Your Honor, may I have a moment?
yes. Yes. Only one. Only count two. Guess we'll do that first, followed by 5 without any penalty. Good morning. Life is good. So he still wants to go to trial?
That is my understanding,
So, Mr.
Your Honor.
Bancroft, I'm going to give you one more pitch.
He's indicated to me he's got some things he'd like to speak privately about, so I
Well,
suggested.
let me make my pitch first.
Yes, sir.
Okay? So my pitch is this. I'm not going to do your trial. I'm at a conference and I'm coming back at the end of the week and I'm going to take a more serious case. When I look at your case, you're what, early 40s?
43, sir.
You don't have any prior felonies. You appear to either have a substitution. If I can make you a convicted felon on this run, it's gonna make it more difficult for you to get services in the future. I'm willing to give you one more chance, and I'm willing to be done with you, and the taxpayer is still housing you. The state was offered you $364, you've done $270 something. You've either that's gonna keep you from coming back or it's not. So if you wanna be done today, you can open plea in front of me right now. If you don't, if you want to keep in the system, you want your stand your ground, which means I probably have to continue your trial. That means you're probably in for another 60 days. You're getting closer and closer to whatever. So that's the strongest pitch I can do.
Yes, Your Honor, I do appreciate it very much. I've been trying to fight this from the beginning of the hospital seeking help, and I don't believe that I did anything necessarily wrong, especially for
So the difficultness that you have is that it's a very high standard to be found not guilty by reason of insanity. So then, whether or not you should be guilty or not, arguably what you argue to the jury is what a proper sentence is up to the judge. Did he violate the law by biting them or not? You decide, did he bite them? Did you decide that they warranted being bit? There's probably a good chance that they say they shouldn't have been bit, they're just doing their jobs. They come back guilty, then you put it right back on the judge, depending on the judge you get and what they may learn or learn more, because right now, I don't know that much detail about the bite and all that.
Yes,
But
sir.
the judge who tries the case is gonna hear all those details, might get upset about that,
Yes, sir.
might decide that you might bite some more people, and you know what? You do score the possibility of prison, and so to make sure, I'm gonna send you to prison.
Yes, Your Honor.
So that's probably why your attorney's probably telling you, you may wanna plead today. And I'm telling you, you may wanna plead today.
Yes, Your Honor.
So there's, I'm married myself, so I appreciate, sometimes I want to be right, but it's better not to be right. It's better to figure out what's the best course of action to move forward.
Based upon the body camera footage and stuff, I think that I have a case, is all, Your Honor.
Okay? I'm not the one who lives with this.
I
You're the
know.
one who lives with it. Only you can make this decision,
Right.
okay?
Yes, Your Honor, and I do appreciate it very much. I appreciate your time and stuff. The best of my knowledge, I think that the law's on my side in this circumstance, so.
Okay, all right.
Your Honor, if I may just put on the record, if the court is correct, I have advised Mr. Bancroft that, in my opinion, to entering a plea today would be in his best interest, particularly given that the prior negotiation would be for a withhold, and he does otherwise qualify for a withhold of adjudication.
So, sir, it's a decision only you can make. I think you're behind the 8 ball a little bit. I've been doing this for over 30 years. seen a lot of cases, but who knows what a jury may do, okay? So I'm gonna take it off the trial docket since your attorney's filing a stand your ground, because there's gonna be a hearing for that first, okay?
That was my intention, to go into the stand your ground, Your Honor, and then from there, figure out a little bit better where I'm at.
Okay.
And Your Honor, as to the second motion, would the court like to reset that to a different date, or is the court willing
I don't
to-
know why you need his medical records.
So one of the one of the things the state has to prove is that the personnel at the time were working within their line of duty. They had been told that he was discharged from the hospital. The state is just looking for more further proof that they were informed that he was discharged and needed to leave. And so the purposes of the medical records would be to prove that he was in fact completed his treatment and needed to leave the hospital at the time. Then he was also not under any influence of medical drugs that would affect his ability to understand or comprehend what the victims were telling him at the time. And so the state believes that there's enough of a nexus to be able to get his medical records, at least this point in time. Now, if they need to be redacted, if they're going to be used at trial, that would be another story. But at this point in time, the state believes there's at least a nexus to be able to get the medical records.
What says the defense?
Your Honor, I agree with the court that largely the medical records would not be relevant. However, the discharge time, I have no objection to that.
So why don't you limit to the discharge paperwork?
Yes, Your Honor, I can do that.
Okay, all right. All right, so I'm going to continue to the next pretrial conference, which will be on August the 11th, okay?
And Your Honor, will his fingerprints be taken today as well?
Yes,
Okay.
I'll grant the fingerprint.
Thank you, Your Honor.
All right, good luck to you, sir.